Good afternoon, everybody. My name is Matt Macnamara with Scott and Wallace. I'll be hosting the Facebook Live today. Robert and Clint, unfortunately, are in mediation and attending to other business, so you're stuck with me for the afternoon. I'm in charge of the Employment and Labor Division for Scott and Wallace, for those of you who haven't watched our previous videos. The types of claims that we handle are discrimination, sexual harassment, wage and overtime, retaliation, and workers' compensation claims. Today I wanted to talk to everybody a little bit about the ADA, which is a federal law that I'm sure many of you have heard about, at least in passing. It's the Americans with Disabilities Act. There are a number of provisions to the act, but parts of the act that we focus on here at Scott and Wallace deal with discrimination in the workplace as well as accommodations in the workplace. Both state and federal law protect against discriminating against an employee due to a disability. Disability can range from anything from a handicap that prevents you from walking if you're in a wheelchair to cardiovascular injuries that keep you in hospital for extended periods of time. It's against the law for any employer to take any action against you as a result of your disability. Likewise, under the accommodations provision of the Act, it's illegal for an employer not to make a reasonable accommodation for an employee. Some common reasonable accommodations would be employees who maybe need a certain type of desk to accommodate their wheelchair, a ramp to get up into an office, and sometimes employees who have disabilities that makes them have to miss work for an extended period of time, even allowing them to work from home on occasion is a type of accommodation that an employer has to make. Not all accommodations have to be made by an employer, just reasonable accommodations. And if you're an employee who suffers from a disability and has asked your employer for an accommodation, feel free to reach out to our office to go over that accommodation you've requested, and we can talk about the type of accommodations that employers make on a regular basis.
Now, Matt, quick interjection here. You've got a question for Megan. She wants to know, does this apply to, does it have to be a current employer, or can it be a future employer, say you're applying for a job?
It's a great question, Megan, and the answer is it applies to prospective employees too. If you're interviewing for a job and some statement is made that, oh, well, we would hire you, but we don't want to have to find a desk that suits your disability or install a wheelchair ramp in order to get you into the building, things of that nature. If you are qualified to do that job with a reasonable accommodation and they don't give you that job because they just don't want to make that accommodation, then you're covered by the ADA and very well could have a claim against the employer that you're interviewing with. Now, one of the issues that comes up quite frequently here is individuals who are off of work because they've been injured and have to miss time for that. Now, those are tricky situations that are dealt with on a case-by-case basis. So feel free to give us a call if you're out of work and your employer terminates you because of your missing time. While an employer certainly can take action for an employee who's missed too much time, at the end of the day, depending on the severity of the injury and the nature of it, they at least have to give you some opportunity to recover and come back to work.
Okay. You got a few people on here saying, hi, Matt. How's it going?
Hello, everybody. I hope everybody had a good Thanksgiving. I know I overate a good little bit, but happy to be back in the swing of things in the office.
That's good. So outside of the ADA, anything else that you particularly cover at Scott & Wallace that might help some other people with work and labor?
Well, on the issue that Megan brought up earlier, most all acts federally and state that apply to discrimination in the workplace don't just apply to current employees, they also apply to prospective employees. They're called failure to hire claims. And again, in those claims, typically it's an individual who is very qualified for the job, more so than the candidate that got it, and they just didn't get the job, and the only justifiable reason that they could think of is because of their gender or their age or their religion, things like that. While employers are certainly able to ask questions that deal with those aspects of an individual's life to a certain extent, if those questions come up a lot in an interview and you don't get a job that you feel like you're entitled to, and they're asking very personal questions about your background, your gender, your orientation, things of that nature, then it's very likely that you could have a claim against that employer because they based their decision on a discriminatory reason.
All right. So where are Robert and Clint today?
Robert and Clint are in mediation, which is common for both of our areas of practice. Mediation essentially is generally court ordered, and it's a way for parties to attempt to reach a compromise and resolve a claim before going in front of a judge and having a selected jury and take time out of people's days. So it's a mechanism that the courts here in Florida utilize quite more than other jurisdictions around the country, but it's a very good, effective way to resolve complaints without the necessity of having to go to court, go through a trial, and expend all those resources. Well, I think that might be it for all the questions. Any questions that y'all have, send in. We'll be happy to answer them at any time. And as always, tune in to us 2 p.m. every Tuesday for Scott and Wallace Live.
And you shared something earlier about the weather tonight.
The weather, I think it's going to get
cold out here, isn't it?
It is. I think it's supposed to get down to 31, I think is what I saw. So I'm not sure if that's, where you got to leak your pipe, so it doesn't freeze over, but it's certainly getting close to that.
Gotcha.
Good fire weather.
Tell everybody here, I don't know if they realize your deep ties in Tallahassee.
I am born and raised in Tallahassee. I went to Florida State for undergrad and then FSU for law school, so I'm a proud local Seminole, and couldn't live in a better place.
That's great. And your sister is with opening nights, right?
Yes, my sister works with opening nights, who helps out with a lot of stuff with Leon County School Board, similar to the work that we do with Leon County School Board here with the firm.
That's great. All right.
Thank you guys for joining us, and we'll see you next week.